Hello, I'm Felicity Gerry QC. I'm admitted in both England and Wales and Australia. I've recently had ad hoc admission in Hong Kong and Gibraltar. I'm also a member of a Maths and Law Research Unit at Charles Darwin University, an Associate Fellow at the Free University in Brussels, and an Adjunct Fellow at the Western Sydney University. My Master's topic is Global Governance, and my ongoing PhD topic is using technology for combating human trafficking. This keynote address is for the International Bar Association conference in 2017 under the title Towards a Global Criminal Law Act. I like to think of my keynote address today as my Uncle Ben moment from the movie Spider-Man. For those of you with short memories who don't remember the Tobey Maguire and Kirsten Dunst version, Uncle Ben had the best line. He said, "With great power comes great responsibility." Our topic for discussion today considers how global trade can bring global responsibility, particularly for corporate liability for offences committed by and on behalf of a company. Unfortunately, to mix my superpower metaphors, today I do not have my Wonder Woman cuffs of steel. And I would like to thank Tim Strong of Taylor Wessing and the rest of the excellent panel today for putting up with my absence due to professional commitments. Those of you who know me will know that I spend a lot of time in the sky, and I would have done my best to be there. I would be there if I could. The threads of this keynote address are threefold. Firstly, understanding the need for globally harmonised legal structures post-globalisation. Secondly, moral issues of criminal blameworthiness. And thirdly, technical issues relating to corporate responsibility and corporate trade. These are not merely questions of extraterritorial jurisdiction, but require thought on where the burden of criminal liability lies, appropriate penalties, or deferred prosecution agreements, as well as compensation for victims. Our panel will reflect on the differing approaches as some nations choose to focus on individuals and others increasingly regulate for corporate responsibility, whether through civil or criminal liability. The role of criminal law in this corporate context is increasingly visible, not just in relation to organised crime, but also in relation to corporate conduct. Increasingly, there are cooperative transnational agreements to tackle exploitation by mandatory reporting, financial reporting in the context of money laundering, funded policing, effective prosecutions and support for survivors. This is part of the UN drive for transformative change. In the context of bribery, corruption, fraud, environmental damage, work health and safety failures, forced labour and human trafficking, for example, many nations now provide for individual criminal prosecution with consequential penal sanctions and confiscation of the proceeds of crime. If we are to consider the responsibility of corporates, particularly global corporates, for systemic failure or a failure of oversight of those individuals who commit blameworthy conduct, it requires consideration of reach. These are no longer domestic issues, but concern the actions of networks of businesses, including subsidiaries. This in turn gives rise to complex legal questions which go further than deciding the proper law for any commercial dispute. Take human trafficking, for example. In March 2016, certain large companies operating in the UK became liable to report under the UK Modern Slavery Act. In practice, this means that each organisation must provide an annual board-approved, publicly available statement that describes what is being done within the organisation to eliminate slavery in supply chains. So far, over 1,700 companies have released statements which are now searchable online. Leading companies include Hewlett-Packard, Apple, Primark and British American Tobacco. The movement towards transparency on issues such as human exploitation and child labour means the impact of the Act is more than administrative. It is said to demonstrate the power of collaboration between governments, corporates and civil society globally to achieve a level playing field. Global corporate organisations function by outsourcing production, often to more than one country. The regulatory framework is therefore a patchwork of differing systems and levels of compliance. It becomes almost impossible for a single nation state to regulate corporate conduct. The risks of human exploitation in global supply chains therefore remains high. From a human rights perspective, it becomes necessary to consider how corporate giants can be held to account for the effect production can have on health, welfare and environment for people who depend on those organisations for their income. From a corporate perspective, the burden of compliance with international human rights goals raises issues not just around jurisdiction, but cost. The way for corporates to cope with an ever-increasing legal and regulatory burden with requirements which differ from country to country brings the issue of harmonisation to the fore. It is perhaps worth pausing to remind ourselves of the elements of criminal conduct and the procedures for a criminal prosecution in most jurisdictions. A crime is generally defined as something serious enough for the state to punish. There is usually a victim, although criminal law can also be used to regulate certain conduct considered sufficiently blameworthy or dangerous. There may be some justifications, defences or excuses. Once liability is identified, a sanction is provided for, although in some jurisdictions there may be a deferred prosecution agreement. In some cases there can be additional financial or restrictive penalties, such as prohibitions on positions of responsibility. Victim compensation is now relatively routine. The same issues arise in the context of corporate criminal conduct. The consequence of criminal behaviour is generally a disadvantage. This can be a business or human cost. Industry standards are now common in economic decision making. In oil and gas, for example, guidelines for good governance are generally followed as a compliance issue in the context of health and safety, often at higher standards than national laws. There is a public expectation that oil and gas producers comply with high safety standards, which has permeated board duties. Those standards have been driven by the cost of keeping people alive and not facing claims for human injury and environmental damage. Here, the maintenance of high standards of corporate behaviour is being hopefully achieved through a culture of compensating victims of corporate misconduct and avoiding the risk of reputational damage. In the context of criminal prosecutions, debate remains as to whether it is right for damages and compensation payments to go to the prosecuting state, or whether deferred prosecution agreements are a sufficiently secure model for accountability, as well as to what extent injured parties are properly represented in a compliance context. But the practical reality is that global corporate structures can develop in a fashion that reflects concern for human rights, and it is capable of doing so in a wider context, subject to the complex technical issues that our panel will discuss. Criminal liability is a mechanism which can be used to improve corporate respect for human rights. Moving towards global corporate criminal liability has already started. Effective prosecutions have occurred. The reach of the UK Bribery Act has set an example as to how one country can impose extraterritorial responsibility on corporates. In the context of modern slavery, a similar process is underway, albeit at the moment with more limited effect. Communities now are much more mixed, and economies are inextricably integrated. Realistically, in the modern world, there can be no trade without migration and no governance without cooperation. Globally, there are now common histories relating to global challenges that mean a shared programme to find stability through harmonisation of legal structures may be possible. Globalisation has brought successes in terms of economic development for formerly unproductive countries, globally improved health and significant innovation, such that we can conclude that it is not altogether negative. In the past, risk was managed by rules made by national governments, and regional solutions were designed to deal with national clashes. However, whilst collective problem solving from all those who operate across borders and globally may sound attractive to deal with, for example, banking failures, the notion is not without a lack of popularity, with concerns over the consequences for business and shareholders. To date, it is the larger nations as producers who've taken the burden of governance, but as development improves, other nations begin to assert their authority, often through regional arrangements. National identity, nevertheless, remains a dominant force. Challenges arise due to the perceived or actual influence of some traditions. Perceptions of over-regulation are challenged by failures to manage crises. Enforcement of international commitments is therefore irregular, and global responses are often incoherent or impossibly slow. Partnerships have become bilateral and piecemeal, and the potential for information sharing, achieving best practice, and effective admonishment have been lost in the confusing array of hard and soft law responses. These are not merely political questions. In the context of outsourcing and supply chains, bribery, money laundering, human exploitation, traditionally the province of domestic criminal justice systems, these become global concerns, where governments and corporates are inextricably linked, but domestic responses are inadequate. The victims of such instability and delay are people and environments. Production has become increasingly organised within global value supply chains, which focus on mass customisation, not economic development. They prioritise the increase in shareholder value, not other human interest. The financialisation of globalisation has led to negative effects on labour markets, with shares of value through outsourcing increasing poverty amongst workers in developed countries and turning people in less developed countries into a global service industry. Money and power is concentrated not in nations, but in investment strategies of global financiers. Trade is measured in comparative figures for imports and exports. It is therefore arguable that the determination to achieve financial assets takes precedence over investment in manufacturing and job creation and trade practices. It is here that the Ruggie principles on business corporate responsibility can be seen as more than just a bolt-on. Importantly, the UN framework recognises and places the responsibility on business enterprises to respect human rights, wherever they operate and in all their operations, whatever their size or industry. The duties on states include ensuring people affected can access an effective remedy. There is therefore a balance between governing and trading with effective enforcement. Broadly, corporate responsibility has been classified under 4 headings. Firstly, transactions and institutional structure and the need for transparency of operations. Secondly, high quality accounting and auditing conforming with regulations. Thirdly, corporate governance and the need for good corporate governance with boards of directors, regulators, banks and investors, credit rating agency and investment analysis all having essential roles as gatekeepers. And fourthly and finally, ethical corporate structure. A firm's organisation and functioning which is conducive to the observance of fundamental values and moral principles, including in relations with those external to the firm, that assure or are significantly affected by its functioning. If the market is to effectively control the acceptability or otherwise of business conduct so that global governance and global value chains become inextricably linked, how is this to be regulated and managed from a legal perspective? My view is that, like any complex legal problem, you just need good lawyers to solve it. Our panel of experts, therefore, have the unenviable task of considering some of those complex questions. Where does or can jurisdiction lie? What standards do we hold corporations to for the purposes of oversight? Do we create criminal deeming provisions to ensure a requisite standard of care? If we can recognise a concept of systemic failure in the context of corporate manslaughter, for example, why not in other fields of commerce that have human consequences? In complex business structures, who is the criminal for the purposes of liability? Who is the company when it comes to paying the penalty? Are shareholder scrutiny and board fiduciary duties enough? How do we tackle corruption, which can dominate all moral efforts to improve business ethics? Where is the balance in asset confiscation and victim compensation? Who is responsible for investigation and evidence collection, and where the issues are to be tried? These are some of those complex questions that I hope they will be able to discuss with you today. Some forces undermine the institutions and values of democracy, ethical values and justice, and jeopardise sustainable development and the rule of law. Transparency International has defined corruption, for example, simply as the abuse of entrusted power for private gain. These are words that could equally be used in the context of other exploitative business conduct, to the point that we can consider corporate regulation by a corporate offence of failure to prevent economic crime, requiring companies to carry out relevant risk assessments in relation to any services provided by associated persons anywhere in the world, and to put in place adequate procedures whilst being otherwise at risk of criminal prosecution. Some multinationals will already be caught by such mechanisms, including the Bribery Act and the Modern Slavery Act that I mentioned earlier on. It becomes clear that we must turn our minds to both our global scope to achieve harmonisation for greater certainty and compliance, and to the mechanisms by which this could be achieved. In my view, the questions for this panel engage every element of criminal law and engage every facet of legal expertise. This can only be at a global level, beyond concepts of dispute resolution, but by upfront corporate crime prevention. I'm not sure that Uncle Ben in Spider-Man would be such a likeable figure if his dying declaration related to global corporate governance, but I'm pretty sure that Wonder Woman would want us to find a way to improve the corporate world. Thank you. Enjoy the panel discussion. Goodbye.